Okay, welcome back, everybody. We have one item left on our agenda, and that is the analysis and recommendations related to the Humboldt Cannabis Reform Initiative. And I believe we've got a presentation that John Ford and his staff are prepared to give us. No need to read anything here, right, Council? Yeah, I think we're good there. Okay. No worries. It was a brief lunch. I think half of us spent most of the time talking about other things. So,
I need to get back into Zoom real quick so I can share my screen.
okay. Looks like the word's getting out. We have 15 attendees. Thank you, Supervisor Bushnell, for getting the word out to the communities, and Supervisor Bone and or others who might have.
Well, thank you, Chair Madrone. Thank you for the moment to get adjusted here. John Ford and Stephen Santos and Cliff Johnson with the Planning and Building Department to present the analysis and recommendations on the Humboldt Cannabis Reform Initiative. And did I stop sharing somewhere?
I can lean back, but it forces me forward.
My apologies for the technical difficulty.
No worries. For those listening but can't view us, we are working through to get the PowerPoint up, or screen share.
There we go. Thank you. My apologies.
Great, thank you.
So we spent some time looking at the Humboldt Cannabis Reform Initiative, and this is just an overview of the report that we provided to you to identify the likely impacts from the regulatory changes. The primary concerns with this have to do with not so much what it will do to new applications, but what it would have to do with existing permitted farms, and more specifically to legacy cultivators who have been in the cultivation business perhaps for generations. And so we're going to really focus this morning's discussion on what that does to the cultivation industry in Humboldt County. It's important to remember that part of the initiative is to talk about what large cultivators do to small cultivators in the county. But as we will point out, most of the so-called large cultivators are actually pre-existing legacy farmers that have been doing this for a long period of time. So if the HCRI passes, one of the most important things to talk about is that many of the farms will become what's called legal nonconforming. I want to spend a little bit of time giving perhaps a planning lesson, forgive me for that, but nonconforming is a very important concept in understanding the impact of the ordinance on existing permitted farms. What nonconforming means is that it's either a use or a structure that was in existence and legally permitted at some point in time, and then the regulations changed such that it no longer complies with the existing regulations that are in effect. What this typically does is it freezes the structure or use at a point in time such that it cannot change or can only marginally expand, but it basically can only be maintained. Sorry, my computer's having a fit. This is further complicated by a component of the HCRI which defines expansion. And one of the phrases in the definition is any increase in the number or size of any structures used in connection with cultivation. So basically, a structure is anything that is placed upon the ground or has location on the ground or is attached to something that has location on the ground. So it's virtually anything. And so the concern with that is that then non-conforming would not allow any expansion of any structures, increase in number. So you couldn't add water tanks, you couldn't add solar facilities, you couldn't add anything that had to do with the cannabis activities on the site. The HCRI also prohibits cultivation of over 10,000 square feet. Evidently, anything over 10,000 square feet is considered to be a large cultivation site. It also prohibits indoor cultivation. It essentially prohibits mixed light cultivation. It does allow artificial light over 6 watts, which is currently the state definition of mixed light tier 1. It also has provisions that any permit that is approved under the HCRI would only allow 1 permit per person and 1 permit per parcel. We'll talk much more about that because all these things, the importance of all these is that these serve to create a baseline for determining existing permitted sites as non-conforming if they don't comply with this. The last one is that it prohibits cultivation activities on less than a Category 4 road. And so even a 3,000 square foot cultivation site that's on less than a Category 4 road would become a non-conforming use because it doesn't comply with the road requirement. So as I mentioned, the greatest impact would be on legacy farmers. And I just want to point out that 74% of the permits that we have, and this is in the report, are over 10,000 square feet are legacy farmers. They're pre-existing. So basically 74% of the approved permits that are over 10,000 square feet are given to people who are pre-existing. That means 26% are for new. So just right off the bat, a farm that is over 10,000 square feet becomes non-conforming because of its size. So the ability to add water tanks, the ability to modify activities, to add uses, add a farm tour to the list of permits that it has would not be allowed. So the choice for a non-conforming use is, or a non-conforming activity or structure, is that these farmers may be put in a situation as the environment changes and they may need to add water storage, as the industry changes and they may need to do things differently. And if they need to make changes to their site, they would either have to choose to make do with what they have, to make no changes, to reduce the size of the cultivation to 10,000 square feet. If they're 10,500 square feet, maybe that makes sense if they comply with all the other regulations that are within the HCRI. But if they're closer to an acre, it may not make sense for them. So if making no changes doesn't work, if reducing the size doesn't work, the third option available to them is to cease the operation, to discontinue the activity. And unfortunately, that becomes part of the decision-making process that would be available to non-conforming farms under the HCRI. It's also important to identify that the same provisions apply to farms that are under 10,000 square feet. They may become non-conforming for different reasons. They may have they may be indoor cultivation. They may be mixed light. They may have more than one permit per person. They may have more than one permit per parcel, and they may, in all likelihood, be on a category less than a Category 4 road. Any of these would deem them non-conforming. And I want to point out that 70% of all the permits that are issued for farms that are less than 10,000 square feet are for legacy pre-existing farms. So by and large, the largest percentage of the population, the largest percentage of farmers that are affected by these regulations are people who were farming before legalization, who did exactly what the county asked them to do. They came out and declared themselves to be cannabis farmers. They gave us their names, their addresses, their phone numbers, and they applied for permits. And they've gone through the process. They've spent thousands and thousands of dollars of money to improve their property, to address conditions that the county's placed on them. And this would put them in a place where potentially they couldn't further modify their site. They couldn't acquire additional permits to keep up with the industry, and that they may be forced to make a decision to discontinue the activity. Another really important component of the HCRI is that it no longer it would change the county's current regulatory requirement to require an annual inspection. This last year, the county did inspect every single one of the permitted sites. And what this would do is change that requirement from an annual inspection to be a renewal. And what is involved in the renewal isn't entirely clear, and that is something that adds significant uncertainty to what is meant by a renewal. It is clear that there is an application that's intended. In the language of the HCRI, it says an application for renewal. So there is an intent that there is going to be an application there. So under today's context, 1,027 active permits, there would be 1,027 applications submitted annually for renewal. The thing that's not clear about this is that what is the intended process for evaluation of a renewal? One of the things that's really important to consider is that the HCRI would require that all permits expire annually, and then the renewal needs to be processed. Normally, when you have an expiration provision within a regulation, you're considering that de novo. You're starting all over and having complete discretion on that every time that that's done. In this particular case, there would be 1,000 discretionary permits a year that the county would be confronted with. I just want to bring up that the approval process that the HCRI identifies is that anything 3,000 square feet or less could be ministerial. Anything over 3,000 square feet would be subject to a discretionary permit, which would, by the HCRI requirements, involve a public hearing. The HCRI also expands the noticing requirements, which would probably cost somewhere in the neighborhood of $1,000 for additional noticing, between an additional posting in the paper and going out and placing notices in the area of the site, having to pay a staff person to drive to sites, post it, drive back. There's a lot of staff time there. There's a lot of cost in the paper. Then there's the additional cost of doing mailing for not 300 feet, we normally do 500 feet, but to do a mile radius. So there's a lot more postage involved there also. So these renewals, just the cost of doing that would be more expensive by approximately $1,000. The other big concern is that there is a section in there saying that after the approval of the HCRI, no permit shall be issued that results in more than one active permit. So the question becomes, what is meant in this particular case by no approval? If you're talking about an approval, a renewal is an approval. So is the intent here that in the context of renewing an application, a site can't have more than one active permit and an applicant can't have more than one active permit? In all honesty, it's not clear what's intended by this. It's an unclear provision within the initiative, and it makes it extremely difficult to implement and extremely problematic. Under worst case scenario, what that would mean is that all the renewals, people that have multiple permits would need to give up all but one. That would probably result in them, well, I can't speculate on what they would do, but it would be very difficult for them to completely change their business model. Under best of circumstances, it would mean that nobody would be able to apply for an additional permit, and that would include people who may want to have farm visits, have tours, do on-site processing, have a community resource facility. Those would not be allowed in addition to a cultivation permit. So what about new applications? There's a cap that's imposed by the HCRI that has already been exceeded. It may be that enough people decide to discontinue with their existing permits that we get down below the number of that cap. But then the question is between the additional regulatory requirements in the HCRI, the additional cost of the noticing, and the limitation on 10,000 square feet, would anybody actually apply for a new permit? So what are the implications of all this? One clearly is that we could see farms shutting down just because they can't comply with the regulatory requirements that have been put in place. Another could be is that the environmental enhancements that have been required in many cases by the Planning Commission, in some cases by the board, couldn't be undertaken. It's ironic that yesterday I signed, I think, 18 agreements to grant money to people who had been awarded DCC grant applications. Under this, if they had any provision that made them non-conforming, most all applications are non-conforming. If that were to occur during the period of time when the HCRI was effective, they would not be eligible to install those improvements. They could not install new water tanks. They could not install the solar facilities. So a lot of potential environmental enhancements would not be able to be installed. And then, you know, the big implication is that we believe that the county has been successful in allowing people to step into the legal market. Humboldt County has traditionally not been a legal market, and we can only speculate in terms of what people would do if their primary legal form of cultivation were to be taken away. So our primary recommendation is to form an ad hoc committee to meet with the initiative sponsors and see if there is an understanding, the recognition that perhaps the way the HCRI has been structured does some things that are unintended, that it has consequences that are unintended consequences, and to see if there's other ways to address some of these concerns. If that proves to be ineffective, there are other alternatives that we would recommend the board consider, working on informing the public of the initiative's impacts, and also to perhaps develop a competing initiative. that concludes our presentation. We'd be happy to answer any questions that you might have.
Great, thank you, Director. Thank you, Director Ford. So at this point, let's take questions and clarifications from the board, and then we'll go out to public comment, and then we'll bring it back to the board for discussion. So are there any questions or clarifications? Supervisor Bushnell, then Bone, and then Wilson.
Thank you. Through the chair, Director Ford, I'm wondering what, because there's 2 licenses involved, state and county, what would happen with a renewal of a county license that would be then inactive? What would happen with the state license?
So when a local permit is discontinued or some change is made, we notify the state. In fact, that's a component of the HCRI also. That's something we already do, but as we notify the state of that status change. And the state conversely notifies us.
So if you have a long process for renewal, and let's just be honest here, it's been long for lots of people to get through that structure, what would happen to their state license when they currently don't hold a Humboldt County permit?
Well, I think that we would ask that we not, or we would work to make sure we're not in that circumstance. And unfortunately, one of the things I intended to say and didn't is that we would really have to so greatly increase our staff in order to accommodate just annual renewals that there would be many more people just working on renewals. That would be an annual thing.
So the process for any staff time is passed to the cultivator?
That is correct.
Are there class 4 roads in Humboldt County that are are there roads in Humboldt County that are Humboldt County roads that aren't class 4?
Yes.
How do you fix that? I'm just making a statement.
Yep, thank you.
So currently there are many cultivation sites that are on leased properties, and also on those leased properties, that owner of that property might have their own cultivation site. What does that do?
Well, regardless of who owns the property and who holds permits, there's a limitation to what can be on the site. So I don't think that would change things. The bigger implications, frankly, are to those sites where we approved a permit for new cultivation, and then people moved RRRs onto the property. And,
Okay. Okay, so currently also, I'm almost done, you guys, for right now. Currently, when you go through the Planning Commission and you, either 2.0 and some of the 1.0s, you get a list of compliance things that you have to complete, sometimes 2 years, sometimes 5 years, sometimes, whatever, it's always down the road. What would that do to that down the road process? So if you're approved by Planning Commission and you are working on your compliance and you have X, Y, and Z to complete, which may be a facility, a drying shed, a rain catchment pond, so forth and so on, and you're allowed to cultivate right now, if you complete these things, what does that do to this?
So there's a couple different questions that I'm going to answer in there, and hopefully I answer the one that you intended to ask. One is that there are provisional permits where we defer improvements for a period of time because the site was pre-existing and they're bringing it into compliance. This would not change that. That would still be the process that people are given, although we're getting to the place where most of that work should be done. Secondarily is that if there's an approved permit that allowed somebody to put up a drying shed or put up some other kind of facility, and they vested their permit, so they started that activity even though maybe they haven't constructed the drying shed, that would still be allowed to go ahead because that's still part of an approved permit.
Okay, last question for right now. Lots of cultivators that are doing outdoor cultivation are now changing to do light deprivation, which is a more sought after product. So if you have 23,000 square feet of pots and you want to change to 23,000 square feet of greenhouse, would you be able to do that under this initiative?
Greenhouse is a structure.
Okay. Thank you.
Supervisor Bone.
Well, this started out, and the process, the neighborhood process, and you and I were, and Supervisor Wilson were at the original meeting up at Nealon School. You were there. Remember, that was one you couldn't make, and you said, I better be there. So, and the process was, the one that they were upset was, I think it was an acre. And I think we settled on 10,000. Is that, what ended up being settled?
So under 2.0, an acre of cultivation can be approved with a special permit.
But what did we prove on the yeah?
Yeah. So that's what the original application was for.
Yes.
What they realized is that if they reduced to 10,000 square feet, that could be approved with a zoning clearance certificate, which requires no public notification, no public involvement. It's a ministerial permit.
Okay. So the process worked on that, and I look at this process and all the meetings we had in 14, 15, 16 to get where we needed to be and everything. And we didn't get a lot of input from the people that brought this forward. I'm going to bet none because I don't remember any, but I don't remember everybody that commented. But I bet you and I have been to 30 sites with trying to work out agreements. And we've worked out agreements on 25, and usually it's to the benefit of the neighbor more so than the applicant. But there was a happy medium, and there was we got road, we cut back, we moved them, we did water. The process that we did all these meetings has worked. And then I know personally how many guys I talked into coming out of the shadows. Most of those guys sitting in the back rows. You wouldn't sit in the front rows, though, would you guys? No. But I'm just saying, coming out because they felt it was the right thing. And I think the best thing is you can't buy peace, is what one of them said. Helicopters, everything else. They wanted to come in and do what was right and support their communities. And then we bring this forward, and since I got hit up twice to sign it as just a citizen, the idea that they were reaching out just to help the small farmer. This was going to help the small farmer. And then, obviously, we've seen the maps they've shown. And, I mean, we have 320 acres total. I mean, like 15 100ths of all our total land is under cultivation. So, as we have sewer ponds. We have more sewer ponds, I think, than we have. But anyway. As we move forward, the system has worked up till now, till we got this. And my biggest issue is a couple of the items on here is about forming an ad hoc committee to work with them. Have we got contact from them? I'm hearing that they do not want to. They don't want to discuss. They have their signatures. It's going to the ballot. So before we spend a lot of time putting an ad hoc committee that has nowhere to go, I'm just wondering, where is that an actuality? Did you get an email?
I have not seen that email. I was made aware of it about 3 minutes before I walked back downstairs.
Okay.
And our presentation was done then. I think one of the things that I may have changed, if I had time, the recommendation is to look at legal alternatives to address this if they're not really willing to, if they've already stated that they're not willing to have a discussion to try to reach a common mind and common understanding of what's best for the entire county.
Yeah, because I think the industry has a small glimmer of light at the end of the tunnel right now. Some of the guys are thinking, that maybe they'll hang on, and there's still a viable industry, which I think they've got the right idea, and it's not necessarily an oncoming train coming at them down the tunnel. It's actually a light that's going to work. But this, from your report, and I think the report's great. I mean, you said it's unattainable. It's probably unenforceable. And it just doesn't put a nail in a coffin. It digs the hole, names the cemetery, and puts everybody in it in a mass grave. And I just don't think that's where we need to be right now. So I would love to work with the parties so we have. But to say the system hasn't been working, considering how many sites I've been to and then how many sites that there has nobody been in here protesting a site that got more square footage after they came in and got it protested. So people are getting their issues addressed. We're working now on the light leakage that is still a problem. But we had 13,500 grows 6 years ago, and we're down to probably 1,500 in the county now. So I mean, and my hat's off to the guys that are still hanging in there. They've got a quality product that there must be a market for. So congratulations. But I'm just saying, as we move forward, is this even enforceable if it passes?
Thanks for asking that question.
Financially and
Well,
physically.
I think one of the difficult things, I don't know what, the decision for the farmers is different than the regulatory decision. And one of the things from a regulatory standpoint that kind of had me conflicted as we were working on this is our experience with Measure S. And in that particular case, we took an initiative and we took existing county code and practice and we tried to marry them. And that's really what's being asked of here, is to marry this initiative with existing code and to change practice. But if you get it wrong, you end up with somebody bringing litigation against you and then the court deciding. And with so much ambiguity with this, there's such little direction with respect to renewals, multiple permits. There's inconsistencies within the text itself relative to Category 4 roads. How are we supposed to interpret what the people understood that they were signing? That's nearly an impossible task.
Well, actually being one of the ones who was asked to sign and listen to the whole thing, and them probably being unaware because I'm so low key of who I was, I was utterly amazed when they were saying all the things that we passed and streamlined so the big growers could get their permits in months, the little growers had to wait, and that we were working with all the outside interests. Those were three of the things that really stood out, and that's, and I understand you're selling a product. I mean, this is the best car on the market. Please buy my car. I understand. Just sign here. It doesn't cost you a dime. It's just going to make it a better place. A lot of people misunderstood what they were signing. I know. I've talked to a few people, and they're seeing little blurbs now going, so this means my neighbor down the road can't put in his solar, the water tanks, just what you were saying, and everything else. I'm not saying there isn't some good in here that's workable, but the thing is, you need to talk to the industry to work with them on the good. And I mean, even if you don't like the industry, you're better off working with them than just trying to shut them down, because I don't think that happens. What it does is we go back 10 years, we go back into the shadows, we go back a couple 100 yards off the road, we go back to getting the water wherever we get it, because that's what we're going to get, is we're going to have people still having to make payments or make a living or live their lives, and we're going to have an influx of black market back. So that's the part that scares me probably worse than anything. And I know the sheriff does not have the forces. You don't have the forces to regulate, to permit them or renew their applications. I know the sheriff doesn't have the enforcement capabilities for the black market right now.
Thank you, Supervisor Bones. Supervisor Wilson, please.
I'm not going to be as quite a wide a brush in this, but I share some of the concerns. The Measure S, I mean, this board or, drafted that. I'm just saying, in our best intention, although I can't even remember if I was on the board when Measure, I don't think so. That was drafted by this board and with the intention of having that come together with existing code. And it didn't, I mean, there was issues in there, and then with relationship to enforcement of it, there was litigation that came out of that. Now, this one was crafted outside this body at professional advice of, planning staff or potentially planners, I don't know. So there's probably more likelihood of those potential conflicts with code. And I think you and I talked about one that was fairly specific, which was in relationship to a discretionary permit required when any change in structure happens on a site. Is there a square footage associated with that? What would that be?
So the HCRI, the way it's drafted, is that anything over 3,000 square feet would require a discretionary permit.
For any change in structure?
Well, that's what's not clear.
Okay.
So expansion, by definition, is a change in structure. Normally an expansion requires either a modification to the permit
Yeah.
or a new permit, perhaps, depending on what it is. And so if it's already over 3,000 square feet and it's a substantial change, and that hasn't been worked out in the eyes of this initiative.
Right.
So we're assuming that it would be a discretionary, even modification, requires a public hearing, yep.
But the term structure is in the initiative.
The term structure is not in the initiative.
Oh, it's
in
not.
our zoning ordinance.
Sorry, zoning order. Okay, that's the
And-
issue. Okay.
And so we're basically using existing defined terms, and this is in the report. We put the
Yeah.
definition of structure in the report.
Yeah.
So it's basically anything that's on the ground.
So, is there something?
definition of structure? Not the definition. Right. Yeah.
The term structure is in the.
The term structure is in the definition of expanded. The
Okay, but, I
definition
mean,
of
it's in-
structure is in the zoning ordinance.
Is in the zoning ordinance. That's true, and it's but I'm just saying in the initiative, the term structure is used.
Yes.
Is it not? That's the part I'm trying to get to, because I have some past experience in a former life with relationship to that and permits and with coastal development permits and stuff. And one thing I've learned is that structure is anything that's constructed, right, or requires construction. And I think it's a much broader term than people imagine. Oftentimes people believe structure means like a house or even a greenhouse or something that you build that has walls associated with it in some form or another. But it's not actually. A structure can be a levee. It can be, putting in a solar array. It can be a water tank with some kind of foundation to it. There's a lot of things that structure can be defined as. And I think that could be very problematic when you're talking about enforcement with relation to this. I'm just saying, I'm just using that as an example of where we can get caught around the axle of litigation, and all it takes is one neighbor, really to say, who's very dissatisfied, and then the whole thing is kind of thrown into a boil. It's just a concern I have. I just want to thank you for indulging my question on that.
Supervisor Arroyo.
Thank you for the analysis. It's very helpful, and this has been a good presentation so far. I had a number of questions, most of which you answered in the presentation. So the one about the permit cap, though, I'm not understanding how essentially we would handle the process of considering new applications, given that we would have met and exceeded the threshold outlined here. Could you speak to that a little bit more?
Certainly. So basically, what it allows is that any application that was complete as of the date of the filing could be finished. And the permit cap is 1.05 times the number of permits that were issued. And I believe it was 900 and something. So we're at 1027 right now, so we're above that. So we could not take in applications for new cultivation. And because all the permits are basically cumulatively exceeding the cap, we're set in place right there.
And just on that same note, you talk about the negative impacts on the continuing implementation of the RRR program, and that's, as I'm still learning about this, will you expand on that a little bit as well?
Absolutely. And this helps to perhaps explain some of the context of the likelihood of there really being a lot more applications. Is that what the RRR program did is it allowed sites to be retired. So the cultivation site may not have had a legal water source. It may have been on slopes that were too steep, may have had cultural resources and just really not a good site to continue to cultivate on. So the ordinance allows those sites to be retired and then remediated. And the remediation process is that it basically gets restored to a pre-cannabis condition. And then it gets relocated to another site. What a lot of cultivators have done, what a lot of people have done, is that they have come in and gotten a permit to retire a site. They've remediated that site, but they have not been able to find a landing spot for that relocation. And so those permits are just kind of hanging out there, and those would be new permits to go onto a site. So those sites probably would not be allowed to land any place. And people have expended money to retire the site, to remediate the site, to clean it up, and now they don't have the ability to relocate it. And unfortunately, what happened with the RRRs, maybe this is a little too much, is that they kind of became commodities where they were sold. And so people are holding these RRRs. And part of the reason that a lot of them aren't landing is there are not a lot of, and this is the key point, there's not a lot of sites left to really receive RRRs that are outside of community plan areas.
Supervisor Bushnell? I'm sorry, staff,
I just
please.
wanted to add one more thing. It's an important feature of the RRR program. The parcel that has the retirement site, there's a covenant, a restrictive covenant that gets recorded that bans cannabis cultivation in perpetuity and also bans development where the cultivation site would be. So some of these applicants that Director Ford was speaking of have recorded that covenant and agreed to that restriction, and under the HCRI, they would have no place to move their cultivation.
Thank you. Supervisor Bushnell.
Thank you. I just want a clarification with what Supervisor Wilson was saying earlier about structures. So my understanding, pretty much two things don't require a permit or are considered structure would be a 5,000 square foot or 5,000 gallon or less water tank, and what size of building?
So there is a difference, and this is
Okay,
really
that's what I'm
important
asking, yeah.
thing, is that there are things that are structures. A fence is a structure. It may not require a building permit.
Okay.
An ag-exempt greenhouse, a hoop house, is absolutely a structure, but it may not require a building permit.
So under this initiative, are those permitted as, or they would be not able to be done? Is that considered growth to an applicant?
Yes.
So anything, okay. all right.
Just to
Yep.
reiterate what Supervisor Wilson was making the point, is just anything you scratch out on the ground almost is a structure,
Right.
literally.
Right. So, okay, well, thank you.
Okay, great. I'll just ask a couple quick questions, and then we'll go to the public, and they're stacking up rapidly here. So there was a lot of comments about how there was a lot of things in the initiative that weren't accurate, and I think you've laid those out quite clearly in your report. We've received some packages and emails from folks out there that I think also has some inaccurate things in them, and I just wanted to try and make sure we have clarity around them. So as I understand it, for instance, there's a comment about a particular company that's a cannabis company, and it says that with the passage of this initiative, they would lose 2 permits due to prohibition on having more than 1 permit. So that's not true, as I understand it. The truth is that even with the passage of this initiative, everybody keeps everything they already have. But if they add a structure or come in for a permit of any kind, then that, and they have a non-conforming use to the initiative, then that could very well cause them to lose their licenses and or other types of triggers, right? But you don't lose those things unless you come forward and make a change.
Well, that was one of the things I was trying to say that is not clear in the
Okay.
initiative.
From your perspective, it's
Because
unclear.
the initiative says that no approval shall result in,
Right,
and so is a renewal an approval?
right.
And can you say that it's not an approval when you have expired the permit?
Right. Okay, but if you're coming in for a permit to add a house or a structure or a greenhouse or something else, that's clearly going to require approval, and that then would trigger the non-conforming use, and you would then have to come into conformance. But you don't have to come into conformance if you don't make any changes with non-conforming.
Well, so one of the struggles here, Supervisor Madrone, is that's mixing some of the complexity of this.
Okay, fair enough.
And so the non-conforming, that's why I tried to break the non-conforming discussion into a couple different realms.
Right,
And so you become non-conforming, and then if you do anything that is an expansion,
right,
you either come into compliance, you can't do it, or you discontinue it. And
right,
then there's the relative to the multiple permits. I mean, the way it's structured, it requires an application for a renewal. So the initiative is clear. It's looking for something more than what our current inspection process currently does. It's wanting an application. So what do you typically apply for? A permit.
right. So your point is that because of the annual renewal process alone, whether or not somebody was planning to change anything or not, that would automatically trigger the non-conforming situation.
Right.
So you might have a year of grace, but that'd be about it.
Right.
So, okay, I just wanted to get some clarity around that. And as far as when these things would take
wait
effect,
and
I've
see where they
seen
go.
a couple of different things. One suggested that as of March of 2023, or 22, actually, I think
Yeah.
it said, when the initiative was first filed.
Right.
But doesn't all of this only get triggered if it gets approved by the voters? So it would be March of 2024 that the triggers would happen and change?
They would become effective
Effective,
on
okay.
that date.
Yeah.
But where the triggers are identified as prior dates, those dates then become definitive.
Well, it gets super complicated there, doesn't it? Yep. Real quick. Okay, that's all I have. Supervisor Bushnell, another question?
I'm sorry, that just, I thought of something. So currently, multitudes of farms are considering reduction. I suspect that when Measure S, whatever happens with Measure S and the market, farms may decide to do reduction in cultivation. And that would be an amendment, I believe. And so what does that look like with this initiative if you were to reduce your cultivation site?
Actually, by practice, we haven't required a permit modification. We just,
So if you're gonna say you have an acre and you are realizing I'm never gonna grow more than a half an acre, and I know that through county we can say, we won't charge you for Measure S, but the state currently does. So I don't know if there would be something that the county and state would have to do to reduce that.
So I think if I understand the question is if somebody decided voluntarily to reduce the size of their permit, they could do that with us.
Mm-hmm.
We would then respond to the state inquiry to see if they were in good standing and compliance based upon the size that they've declared to us. So that I don't see that as being a complication.
So if you were to remove, say you had an acre of greenhouses and you decided you're done, you're only going to do half, and you're going to shrink your cultivation site, and you're going to remove those structures, move your water tanks, to accompany the state to be able to reduce your square footage as well, what would that do?
So that could be done. And then if somebody declared that they were doing that with us so that they would minimize their tax liability, and they stayed that way for 2-3 seasons, they could end up, that would be the non-conforming level that they were then at, not the original acre they were approved at.
Thank you. That's the answer I was looking for. Thank you.
Great, thank you for that. When we first had the presentation on the initiative, what was it, 5-6 months ago now, there was some talk that a lot of people might rush in and try and get a lot of expanded permits or this or that or different things before the initiative passes. But your comments about the annual renewal process and other things, I mean, are you seeing a trend of people coming in wanting to quickly expand or do different things right now? Is that a trend at all, or?
We've not seen that. People
Okay.
have joked about it.
Yeah, because
Offhandedly, but
it doesn't seem like it makes any difference with annual renewal. If this passes, then you're non-conforming either way. So you'd be making all this expense to do something that then probably gets taken away later anyway, if it passes, which who knows where that's going to go. Okay, well, thank you, board, for the questions, clarifications. Supervisor Arroyo.
I know we're going to go to public comment, and there are probably many strong feelings about this matter, and I just wanted to make the statement that, staff recommendation here is in part for us to take some action to form a collaborative group we don't know whether that will be successful, but the concept behind that and what the board's direction was previously was to work with the writers of this initiative to see if there is any way that we can address the concerns that you've brought up. And I, from my perspective, I especially want to address the concerns about our capacity to actually fulfill the requirements of this, as well as, of course, address the community need with our local businesses. But I guess I say this in the spirit of noting that we still, I hope we have a collaborative working relationship moving forward with the people who have brought this forward so that we can actually dig into some of these questions about things that were infeasible or unclear. And so I just wanted to say that before we kind of launch into further discussion about what to do next, because the hope is that the writers of the initiative will collaborate with us. And so, that's more of a statement of intention at this point than it is a question or anything along those lines. But, I hope we can, even though we've pointed out a lot of pretty problematic things, and I'm sure many of the public commenters will point out some very problematic things for them, still hope we can move forward with collaborating with them.
Thank you very much, Supervisor Arroyo. And so with that, we've concluded some of the questions and clarifications. So what we're going to do is go to public comment. And it is 2:00, and I have 35 folks in the Zoom. We've got about 18 to 20 people here in the room. If you do the math, if we had 3 minutes per speaker, we'll be here till probably 6 o'clock this evening. I do have a couple of board members that need to get on the road later this afternoon, and I don't want to quell public comment, but I am going to reduce comments to 2 minutes. And as Supervisor Arroyo said, let's focus on what we can do to try and move forward. There's a couple of recommendations here for our board that we're going to be considering to be able to move forward. And we're going to start with those in Zoom, and then we'll go to those in the room. But I'll ask for, or Supervisor Bushnell, you had another comment?
I do want to respectfully ask you to allow for 3 minutes for people that have done that, and to maybe ask the group to just keep the comments, to ask our community to respect that. You didn't warn them this morning. They have set up for 3 minutes. If they cannot repeat themselves, that would be good, but I don't think that's, I'm just going to respectfully say that's not fair last minute.
I understand exactly what you're saying, but we could easily be down to 3 board members at the point that we're trying to consider the issues and make some decisions. So I'll go to the rest of the board. What would your preferences be? I'll start with Supervisor Bone.
I'm staying until the meeting goes. It's just supposed to start snowing in Laytonville, so. But with that being said, before we go to to commenters, can we hear from the writers of this if they're even going to collaborate? Because if we're going to hear, well, I want to collaborate, and they say, nope, we're going to roll our dice and go right to the voters, then that changes everything on here.
Mm-hmm.
So we may not need 2 or 3 minutes, because if they're not going to collaborate and we're not going to get anywhere, make a motion as a county to come out against this and let it go to where it's going, I guess. I don't know, but I would love to hear actualities that the writers of this initiative would even consider. And if they don't, then we respect what they've gone through, and they got the signatures the way they had to get them, and we'll deal with it that way. But I don't know if we need to waste, and I don't necessarily mean waste, but spend everybody's time on something that is not going to come to fruition.
Okay, so I've got 2 items that we're going to come back to here real quick. Supervisor Wilson, what's your preference?
I kind of lean on both Supervisor Bushnell and Bone with relationship to. I think the audience knows that. Well, you've expressed that we have a little tiny bit of a time crunch for a few of us, but that's okay. We do want to hear from people, and so if you'll get to the point, that'd be awesome.
Okay.
I also think that what Supervisor Bone is saying with relationship to, like, if we're going to enter into a negotiated process, and because there are 2 or 3 people that are, have that authority to be able to do that, then we should probably find out sooner rather than later, because it is on the agenda. Mm-hmm. And so there is an expectation around that. And also, if we have a lot of commenters, I don't want them spinning around in circles on something that maybe we might be able to find.
Understood. Okay. Supervisor Arroyo.
I concur. I'll hear people out, but I'd love to hear from the writers of it about what their intentions are.
Okay, so we've got 2 issues. We're going to go ahead and stick with the 3 minutes. And as Supervisor Bushnell and others have said, if you can be concise with your comments, that will be fantastic. Sometimes you can simply come up and say, I am opposed to the initiative for these reasons. Bam, bam, bam. Or I support the initiative for these reasons. At any rate, we'll stick with the 3 minutes and honor that. I appreciate the board. It sounds like they're willing to stay as long as they need to. The only reason I did it was because when I mentioned that, I was working with information that has now changed in terms of the board's availability. As far as the initiative proponents, they're certainly not in the participants Zoom, and it's difficult to know if they're in the caller Zoom because they are only phone numbers. So what do you think, Nikki? We could say, if you are the proposal initiative folks and you want to talk, raise your hand right now and we'll watch to see what hand comes up. But there's already like 20 hands up, right? So, yes.
Sorry to interrupt, Chair Madrone. Just one point of clarification from the county's perspective as we move forward with this discussion and discussing what communications the county can put forward around this initiative. We are not able to take a position of opposition or support. So any county efforts will be to educate the public on impacts, pros and cons. So just as you frame your context around what the county can do, it's important that we don't represent that we will be opposing or supporting any particular initiatives. Thank you.
Thank you for that clarification. Nice to be able to follow the rules, basically. So, again, I don't know that the initiative proponents are here, and I haven't seen any new hands come up. So as much as we'd like to have that, I would suggest that if they are here, people would love to hear from you in regards to the comments that were made about your willingness to work with folks to try and improve areas that need improvement, and then ultimately drop the initiative potentially. But of course, there's a lot of work to do to get to that place. So if you are here, we'd love to hear from you at some point today. But at this point, I can't identify if they're in the queue or not. Okay, so we're all good on that? Yes, Supervisor Bushnell.
So we all received an email, I
Yep.
believe, on March 6th from these folks that states exactly what their intentions are.
Would you like to read that?
Sure. So we regards to recommendations, make a motion to form an ad hoc, our motions. The initiative was agreed by 7,000 plus informed Humboldt County citizens and had more than the legal required number of signatures as determined by the Humboldt County Elections Office, and therefore should propose for voters' consideration on March 2024, period.
Great, thank you for that. And, you know, in your presentation, Director Ford, correct me if I'm wrong, but I think I heard from you that there may very well be some areas in our cannabis ordinances that might need some improvements and some consideration, but this initiative doesn't get us there. It creates a lot of other, as you said, unintended consequences potentially. So I think that, you know, that's another spirit of how to come to this. You know, are there things that we can do to improve? But that's not going to all happen here today. But that is certainly, I think, ultimately our goal. Whether it's cannabis or anything else, if we think there are issues we need to correct, then we need to work on those things. So I heard that. That sounds accurate to you? Okay, great. Yes, Supervisor Arroyo.
Sorry, so this is from one person involved in the initiative, and I still think there could be room for conversation around what the idea is of, you know, modifying. One of the proposals here was to consider modification of the ordinance. I still think it's worth an attempt to reach out in person and communicate around that. I'm not saying that would be successful. This seems pretty clear, but my interactions with the folks involved have led me to think that there's a few different perspectives going on, and so it might be helpful to just have that communication and consider the one of the elements of staff recommendation about still, you know, attempting that.
Great. Yes.
One thing before we get the comment going, and I'd like clarification from the from our council around what Supervisor Arroyo just said. So can one person modify, or does it take all three?
The statutory requirements regarding withdrawal are somewhat unclear as to whether or not it requires one or all three. It's our office's opinion that we will take the position that it does take all three.
Yeah. Okay. Thank you for that.
Great. All right. Okay. Well, let's jump into public comment, and appreciate your patience here in the audience here today. We've got a significant number of hands up in the Zoom, and the first one. Oh, first, let me say, if you are in Zoom remote and you're watching this on our streaming video, it is delayed. So if you're listening to the audio there, you could easily miss your time to speak. So turn your audio off and just listen to your phone, and that's your best way to get a cue on when you're called. So the first number is 6520, *6 to unmute, and you have 3 minutes. *6 to unmute.
I'm sorry.
No, there you go. Good.
I'm sorry. Can you hear me?
Yes.
Thank you. Hi, my name is Vanessa Villare, and I have a 1,300 square foot interim permit that I applied for in 2016, and I also have a consulting firm that helps cannabis farmers with their cultivation licenses. And I just wanted to say that the ordinances that are currently in place provide a robust protocol for monitoring and environmental stewardship. Years of work by not only the planning department, but also by the Board of Supervisors has created a path forward that works. It holds cultivators responsible with yearly inspections, monitoring reports, and fee payments. If you look at other counties surrounding Humboldt, that have very restrictive ordinances that do not follow an EIR, you can easily see our success as a county. Humboldt County had a very comprehensive EIR completed. This EIR lays out all the issues that Humboldt County would have to change to support a legal cannabis industry. It allows for CEQA guidelines to be met and exceeded. Through property mitigations, projects are brought into compliance to meet the guidelines of this environmental impact report, therefore making Humboldt County more environmentally compliant as a whole. To allow this proposed policy to continue any further is to negate the time, money, education, and resources that were put into writing that environmental impact report in the first place. This new ordinance would push people back into the illegal market, and the ordinance clearly states that it does. The new ordinance clearly states that it does nothing to have an impact on the illegal black market growth. Therefore, it's just cultivating a culture that would put the black market back at the forefront of Humboldt County. As a person with a 1,300 square foot interim permit, this ordinance also stops me from getting a permit, as I don't have the required infrastructure I need because of regulations that have changed along the way, and I need more water tanks. It also, I would not make the cap. We've already exceeded the cap in permits. So with this interim permit, I'm not approved yet, but I applied in 2016 with 1,300 square feet. All these reasons combined, plus with the fact that the authors of the initiative will not sit down with us and take the time to actually make this work out better for all of us. I tried calling them on multiple occasions ahead of time and was confronted by people at Bayshore Mall with misinformation about what was actually in this ordinance and asked to sign it, which I did not. I really think that the Board of Supervisors needs to do whatever they can do to stop any of this from moving forward, and let's work as a community like we have in the past to make things better, because things are working in Humboldt County and they are working well. Thank you very much.
Thank you, commenter. And next we have 1180, *6 to unmute. There you go.
Hi, thank you. I first wanted to point out to the public that as someone who was approached to sign this petition, having previously read the initiative, I felt that they were misleading people to get them to sign it. They were not disclosing everything that the initiative would do to the cannabis program as it stands. And I think that they were just saying whatever they could say in order to get people on their side, whether or not people really understood what they were signing or not. Beyond that, you know, we have a problem with our roads in this county, and cultivation required to be on a Category 4 road would make most of the permitted farms non-conforming. If renewal constitutes a new approval, this would put most farms out of business. The 1 permit per person limit would also shut down people that have multiple permits if approval includes renewals. Most of these farms are pre-existing. This would also prohibit people from vertical integration in order to compete in the state market where other counties are allowing vertical integration. They wouldn't be allowed to add a micro business, processing, anything to their current permits. Additionally, a 10,000 square foot cap would take 416 currently active permits into non-conforming status. Again, most of these are pre-existing. Large-scale growth in California are farms that have 100 acres, 60 acres, huge grows, truly large-scale cultivation, and they're already legal in many counties. This would take Humboldt County completely out of competition in the state market. Again, no ability to add additional infrastructure without permit modifications and an additional hearing would prevent people from adding the infrastructure that would enable them to store more water, transition to solar power, and be more environmentally compliant. This is the opposite of what they're saying this initiative is supposed to be focused on. Having permits expire annually when state licenses do not run on the same timeline would push all permittees into insecurity every single year. It would add cost to the permitting program for annual reviews. It would also cause county staff to review 1,000 permits a year, which would maybe break the planning department. I don't know how they would even be able to do that.
30 seconds.
Additionally, regarding public noticing, they asked that staff should go driving around to all notice properties and physically post notices in public areas near the project sites. That would add unnecessary traffic to the roads, increase the carbon footprint, and add litter in the form of paper notices stapled to trees or wherever they could be posted. And again, this is the opposite of environmentally conscious.
Thank you,
lastly, I
commenter.
want-
That 3 minutes goes quick. Our next is 3025, *6 to unmute. You have 3 minutes. There you go.
My name is Ken Hammock. I'm going to keep this really brief. I spoke a number of months ago when this originally came up. This is not only complex, and I really appreciate Director Ford's outlining of all the difficulties and confusion around this complex initiative, but this is anti-community. We've been treating cannabis community here as a separate community for a long time. They've come into the light, they've got their business license, they've showed up, and they're stewards. I've seen it on many farms that I've visited throughout the county. I implore, and I really appreciate the supervisor's comments today. I really implore all of you to continue to fight this. And I've heard personally from a number of folks that feel like they were misled when they signed that document. Thank you for your time today.
Thank you, Speaker. And next we have 7429, *6 to unmute. There you go. You got 3 minutes.
Hi, good afternoon. This is Roby Tenorio, and I'm calling to say I do not support the initiative for several reasons. And the thing is that I understand why the initiative was developed and received enough public support to qualify for the ballot. That understanding is because your board and the public are and have been somewhat misled by the planning staff with this current staff report. This report continues the fable of existing. The people who are upset by the enlargement of the industry are seeing with their own eyes that enlargement. Many farms may have been pre-existing, but they were not over 10,000 square feet. They were not 20 greenhouses covering the meadows. They were not a half an acre. They were not an acre. And that's a pure and simple fable. The ordinances are based on forcing farmers to go big, to lie about what is existing. And so the people are upset because they see expansion not existing. Farm may have existed, but on a much, much smaller scale. And for staff to insist that there is less growth, so there is less impacts, loses reality because the farms that are permitted are significantly larger in square footage. And until this fable is admitted, there will be no agreement with folks who are upset and want the expansion to stop. So again, I do not support the initiative, but until we get honest, I'm afraid that resolution with the folks who are upset will be too difficult.
Thank you, commenter. And next we have 3729, *6 to unmute. There you go.
Hi, can you hear me?
Yes.
Great. My name is Shannon Hughes. I live out in Willow Creek. My husband and I have a small farm called Full Cup Farmstead. Today, I'd like to speak to the residents who may have signed this petition without a full understanding of the reality behind the initiative. I'm going to quickly read a statement that my mother-in-law put on her own social media and gave me permission to read. She signed the petition. Approximately 6 to 12 months ago, I was approached in the Safeway parking lot in McKinleyville by a man who asked me to sign a petition for the Humboldt County Reform Initiative. When I'm asked to sign a petition, I usually do not have time to read the whole initiative, so I always ask what it is about. The man told me that it was to support and help the small cannabis farmers in Humboldt County. I'm all about helping our local small farmers, so I signed it. I have come to understand that the initiative not only does not support small farmers, but would make operation more difficult in several ways. I believe I was misled as to what this petition was really about. I have learned my lesson not to sign one of those petitions without reading it unless I have full knowledge of it already. And unfortunately for people hired to obtain signatures, I almost never have time to read something in a Safeway parking lot. I will probably no longer sign petitions in parking lots. If you signed this petition thinking you were helping small local cannabis farmers, you were also misled. We cannot rescind our signatures, but we can certainly correct this by voting against this if it makes it to our ballot. So that's the end of her statement. And as a small farmer, I'd just like to say, let me be clear, this initiative is not in support of small farmers. This is an anti-cannabis initiative from Humboldt County. No small farmers are speaking out in favor of or standing with the proponents in support of this initiative. Director Ford clearly lined out the flaws and short-sighted facets of this initiative. So please don't be confused or misled. The proponents decided to write policy without consulting anyone educated or experienced in Humboldt County cannabis. And after hearing from small farmers and county staff, they have so far refused to discuss changes or pull their initiative. So simply put, this is written for them, not for the small farmer, and any statements by the proponents suggesting this is written for the small farmer is 100% dishonest. Thank you.
Thank you, commenter. And next in the queue, we have 8463. Star 6 to unmute. There you go.
Hi, can you hear me?
Yes.
Okay, perfect. Hi, my name is Wendy Kornberg, and I operate Sunibus, Humboldt's Full Sun Farms down in Southern Humboldt. And I have deep embarrassment and chagrin to say that I am one of the people who signed that petition. I was absolutely misled. I was told that this same thing would help small farmers. It would help us, fund our road infrastructure, which of course is not true, and that it would also be an initiative against any incoming large-scale farms. I'm just here to voice my opposition. I'm not going to take a lot of time, but I also am encouraging anybody who may be listening and may not be aware of what went on, that this initiative was, given to the people to sign without full disclosure of what it was. I also normally read things entirely, and I did not this time, and I, again, will never do that. I will never sign a petition when I am distracted with my kids or at a farmer's market, and that's unfortunate because there's a lot of good petitions out there. Thank you.
Thank you, commenter. And next we have 5141. Star 6 to unmute. There you go.
Hello, my name is Nick Erickson. I'm owner of Full Moon Farms. In light of your guys' time crunch and to avoid redundancy of a lot of the key talking points that's already been covered, I just want to ask the board to oppose this initiative today. It's absolutely absurd that 3 people can wield so much power over so many people and families in this county that they've never met in person or are willing to sit down and communicate with on this. So yeah, please just oppose this issue. Thank you.
Thank you, commenter. And next we have 4585. Star 6 to unmute. There you go.
Good afternoon. Thank you for having this today. My name is Nicole Riggs, and this initiative, which I've heard referred to as the Karen Initiative, is as misleading as it is dangerous. It's misleading because the proponents gave false facts when they solicited signatures, and it's dangerous because it will cause devastation not only on small local farms, but on our rural economy as a whole. Do we want Humboldt to be just another part of rural America, bleak, devastated? That's what you get with the Karen Initiative. I'm part of the Cooperative Agriculture Network, and we run an academy training farmers to develop a cooperative sector in cannabis here in Humboldt. We are solutions-oriented, and we want to see the entire region thrive. That means stable farms, quality products, and economic growth. If this initiative passes, our work will be for nothing. Just look back to 2016 when cannabis was legalized. With legalization, the state of California had 4 main goals. 1, promote public health. 2, reduce the size of the illicit market. 3, offer legal protection to responsible actors. And 4, capture and invest tax revenue. Stop at number 2, reduce the size of the illicit market. What's the illicit market? It's those that have not gone legal. It's in the pockets of the illicit market that the water diversions have happened and environmental degradation has happened, big trucks and noise. All the things that the proponents are concerned about. These issues arise in parts of the non-permitted or non-compliant industry. The ones that we care about, the ones that the proponents say they care about, are the small permitted farmers. Permitted farmers follow the rules. They comply, they install water storage, They have their product tested, they pay fees, they have inspections. The report has stated that 90% of active farms has no violation. Farmers are motivated to comply. But ask yourself, will this initiative cause the cost of compliance to be greater than the cost of non-compliance? If the Karen initiative passes, farmers will be incentivized not to comply because the cost of compliance will be too high. In fact, they'll be insurmountable, and the unregulated market will appear to offer greater economic advantage. Farms will shut down, and those that remain will have to be illicit. And with illicit comes increased risk of water issues, environmental issues, road issues. All the things that the proponents are concerned about, they'll be worse. The current initiative is misleading.
30
the
seconds.
Initiative is if the proponents are sincere, they must withdraw it. Thank you.
Thank you very much. And next we have 5602. *6 to unmute. There you go.
Hi, my name is Matt Kurth, and I'm the owner of Humboldt Cannabis Tours, and we're based in Eureka. We do cannabis farm tours out to legally permitted farms. I was, when all this was going down about first a year ago, I was told by the proponents of this, the people that filed it, that it wouldn't affect tourism. And now we know from Director Ford's presentation that, my reading was that he mentioned tourism twice in that presentation, and my read is this would completely destroy cannabis tourism within 1 year. As soon as anyone has to renew their annual, if the permits become annual and they have to renew it annually, and tourism is a addition to the permit, that means even anyone who has a tourism permit, of which we only have 3 right now, they will, as soon as they have to renew their permit, they will then they'll have to choose between their cannabis permit or their tourism permit, which means they'll lose their tourism permit. Anyway, so it turns out this is an existential threat to cannabis tourism. So if we want to do cannabis tourism at all in the future here in Humboldt County, that means this initiative can't pass. What I would hope the board does is, the people don't really seem to want to negotiate. I guess try to negotiate with them, but I don't see spending a lot of time on that. I think we need to draft a competing initiative that makes this initiative void. And the only people that can do that are the supervisors. So I really hope that we can not spend a ton of time trying to negotiate with, frankly, economic terrorists, and we can spend time drafting a competing initiative that will just make this not matter, if that's a possibility. Thank you for your time and consideration. I know cannabis tourism is important to those on the board, and this initiative will just make that never happen. So thank you so much for your time. That's my comments. Thank you.
Thank you. And next we have 9687. There you go.
Thank you, Supervisors. Kelly Flores with Margaret Advisors. As other callers mentioned, it's telling that no small cultivation or craft cannabis organization, no cooperative or trade association has voiced support for this initiative. And to propose that its purpose was to help small farmers was a misleading declaration that was used on unsuspecting voters to obtain signature. Also, if you look at the map submitted in page 6 of our public comment, it's from their own campaign, and it makes it appear as though cannabis is taking over the county. But the reality is less than 1 square mile has been permitted. And if you compare that with other agriculture, that currently has 970 square miles, which means 27% of the land use in the county is for agriculture, but just 0.016% is for permitted cannabis. Now, we know the most significant potential impacts on the environment are actually from illegal farms, because they have no oversight from the county, from Fish and Wildlife, the Water Board, or any other agency. And this initiative doesn't address that. And something that wasn't actually mentioned in the language of the review that was done was that the initiative can't be changed. The language can't be changed. It can't be improved by the board. Only the voters with another ballot. It's too restrictive. And as the director showed, this initiative would prohibit any expansion on legal permitted farms, including new solar systems, new water tanks, new rain catchment ponds. It really does nothing to support the environment. Now, as the saying goes, you can't ban cannabis, you can only ban legal cannabis. And due to the rigid restrictions of the HCRI, honestly, we should just call this what it is. It's a kill legal cannabis ballot initiative. And it has the potential to make operating a legal cannabis farm untenable. And the result would push some farmers back into the illicit market, which they've worked so hard to put behind them. We recommend the Board of Supervisors firmly express the negative impact of this ballot measure to the public and vote to consider legal action or even your own ballot initiative with correct ongoing issues for craft farmers. We believe this is necessary. We have to preserve the investment that's already been made over these last 6 years by the county, by the farmers, and honestly by the taxpayers who've actually paid to build a legal cannabis industry in Humboldt. Thank you so much for your time.
Thank you.
Can we pause for a second? We've lost a significant number of people. I know we still have a quorum, but I'm a little.
Yes.
But.
We will pause for 5 minutes, waiting for our folks to return.
Okay. For those on the phone, it was just that it was a little surprising and.
Thank you. So we're going to take a 5-minute break.